All right, this is cause number 203000986F. All right. State of Texas versus Timothy Johnson. Is that you, sir? Mr. Freener, do you waive arraignment and reading of the state's indictment?
We do.
And Mr. Johnson, can you read, write, and understand the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
You understand that you have an absolute right to a trial in this case. However, by entering into the deal with the state, you're waiving that right. Do you understand everything you signed? Did you go over it with your attorney?
Yes, sir.
In fact, you were actually set for pre-trial today. Is that right?
Yes, sir.
You were actually set for trial for June the 28th. And we were going to have a pre-trial hearing today. However, you have decided to take the deal that the state has offered. Is that right?
Yes, sir.
And that's what you want to do. Is that right?
Yes, sir.
You've been charged by way of indictment with the third-degree felony offense. However, it's been enhanced to a second-degree felony offense of assault, family violence, impede breath or circulation.
No, yes, sir.
Just for clarification on the record, as indicted, he had 2 prior penitentiary trips. Those enhancement paragraphs were put on him, so making it 25 month punishment range. We would amend one of those paragraphs to enter into a plea deal today.
So, okay, so we're clear. It says second-degree felony.
And we may need to verify on the judgment.
I think, and if that is the case, then the judgment needs to read differently here because it says enhanced to a second degree.
Punishment, it should be.
Right.
Because if I was a 3rd-degree felony enhanced to 2nd degree.
Isn't that what I said?
That's correct, yeah.
Still, third degree.
Well, it's
But it's the punishment range.
it's a third degree with an enhancement paragraph. You understand that?
That's correct.
But it is punishment range is that of a second degree felony.
Yeah, that's okay. That's more clear. Yeah, it's still a third, but we're getting the punishment range of a second, correct?
Correct.
Okay.
Yes. Sorry.
But basically, what that does is enhance it to a second degree.
That's all, yeah.
Okay.
Just
I
making
mean,
sure.
how would you treat, that's what I'm saying, how would TEC treat that as a 3rd degree or 2nd degree?
Third degree.
Yeah, it's a third degree indictment with the enhancement. Well, nobody in this room can tell you how parole will treat it. And that's what I want to make abundantly clear here, that neither your attorney, state's attorney, nor myself have any control over what parole does. So that's the range of punishment then, is that of a second degree felony, which is 2 to 20 years in the institutional addition. You understand that?
Yes.
That is the range of punishment that you're looking at. Knowing the range of punishment, what you're pleading to, how do you plead, guilty or not guilty? Are you pleading guilty because you are in fact guilty and no other reason? Anybody forcing you to do that? And you're doing that on your own free will, is that correct? Well,
Yes, yes, yes.
I want to make it very clear.
Yes, yes, yes.
You have an absolute right to a trial.
Yes, no, I do not want to go to that is, no, there's no trial, see what happens.
And you can go to trial. You don't want to do that. You're pleading guilty because you're guilty. Is that right?
Yes.
Is there a recommendation from the state?
Yes, Your Honor, the recommendation for the state in this cause is 20 years in the Texas Department of Criminal Justice, as well as an agreed lifetime protective order on behalf of the protected person, Tanya McLawn. As part of this plea agreement, we are 1245ing cause number 20-30010-86-F, and we've submitted a dismissal on that cause to the court.
And the victim's aware of this plea deal, is that correct?
Yes, Your Honor.
And is that your understanding of the plea agreement?
Yes, sir.
And you understand by accepting that plea agreement, you are waiving your right to appeal. You'll have no right of appeal.
Yes.
Anything from the state?
State's Exhibit 1 is assigned judicial discussion and stipulation of evidence. We'd also ask the court to take additional notice of that.
No objection.
States one will be admitted and the court will take judicial notice of the entire content of the court's file.
State yours.
I highly suggest you talk to your attorney first,
Step away real quick.
No.
Let me take it real quick, Judge. May I-
off the record for a second. If we go back on the record, you understand what you're doing.
Yes, sir. Totally.
All right. So go back on the record. Anything from the defense?
Nothing further.
Rest and close.
Close.
Both sides had and rest and close. I will find the evidence sufficient to find you guilty. We'll find you guilty. Since you're 20 years in institutional vision, there will be court costs attached to that. Is there any legal reason why sentence should not be imposed?
No, Judge.
Therefore, is the order and judgment decree of this court to be taken by the sheriff of this county to an authorized receiving agent for a Texas Department of Criminal Justice, where you shall be confined for a period of 20 years. Your sentence shall commence today. You will get credit for the time that you have already served. We're off the record. Please step right over there, fingerprint. You're welcome.